Hello, good day again, everyone. So let's continue our discussions already with this part of our subject. So under section 1, Pure and Conditional Obligations. So we will just continue kasi it's a quite long topic, and then it's quite complicated as well. So hindi may natin isa-isa ang bawat provisions. And then as a continuation, let's discuss under Article 1190 of our topic. So Article 1190, if we have to read the provisions, when the obligations have for their purpose the extinguishment, wait lang, atin pong lalagyan ng linya para po tayo hindi mawala. So when the conditions have for their purpose the extinguishment of the obligation, the parties upon the fulfillment of the said condition shall return to each other what they have received, and in case of loss, deterioration, and improvement, the provisions which with respect to the debtor are laid down in the preceding article shall be applied to the party who is bound to return. And then for obligations to do and not to do, the provisions of the second paragraph of 1187 shall be observed as regards to the effect of the extinguishment of the obligation. So nakikita natin, we've seen here under the provisions of 1190, basically talaga ang sinasabi din yan or ang dinidiscuss niya is about the effects of a resolutory or the effects of the fulfillment of a resolutory condition. Bakit po? Yan po, malinaw po yung mga extinguishment, the obligations for purposes of the extinguishment of the obligations to give and obligations to do and not to do. So what would happen if a resolutory condition has been fulfilled? So basically daw, if in case it is an obligation to give or an obligation to do or not to do, meron po tayong pinapakita diyang mga effects. Firstly, in obligations to give. So basically, may extinguish na ang obligation. Tama ba? And then the parties at the same time are obliged to return to each other what they have received under the obligation. So, kung natatandaan ninyo, kapag resolutory, I would lose the rights. Automatic na acquire mo ng ang right upon the constitution or creation of the obligation. However, it would be subject to extinguishment or stoppage once the condition has been fulfilled. And then the effects nga, as what we have discussed prior, is that the return as to the original position of the parties prior to the constitution ng obligation. So the effect of the fulfillment of the condition is retroactive. And then there would be mutual restitution. And then not only hindi lang restoration or return of the thing itself, but also the fruits and interest. So in case daw the thing to be returned is legally in the possession of a third person who did not act in bad faith. So let's say for example, it has been on a third party who has been a buyer in good faith. Protected yan under the law. So you have to respect that. We have to respect that. So kaya po, importante din na if you have, in cases that you enter transaction or acquired property through a conditional sale, you have it inscribed in the registry of deeds to inform third parties that there has been an encumbrance or burden. Para alam nila at may habol ka in case man. If the condition is not fulfilled, the rights acquired by a party become vested. So, ibig sabihin nito, kapag hindi daw na fulfill ang condition, the rights acquired by a party has become vested. So, let's say for example, so we have here, aside from this example, if I would say, I gave you my land, my 1,000-hectare land, assuming I have that, I gave you my land on the condition na you would not go to a cabaret, o hindi pala, di kayo pupunta ng playmates. We have that agreement, or we have that obligation last January, entered into last January, na dapat within the year ay hindi ka pupunta nga ng playmates. But however, yesterday, I've learned that you indeed go to playmates din sa may balagtas. Eh di ang mangyayari po diyan ay yung lupa na I gave you, you are to return that plus the fruits and interest if there would be any na natanggap, and then kasi nga naman on the reason na you have violated my condition. So yun lang yung pinaka simple example diyan. So if there are any improvements by time in nature, ang mangyayari ay, as the ones that have given it to you, I am as well entitled to the improvements. And then here, let's say for example, meron ditong example. Assuming that D obliges himself to allow C to use the former's car. Until daw na si D hanggang si D daw ay returns from the province. So, upon the return of D from the province, dapat si C must give back the car. So, ang nangyayari ay yung conditional return from the province, and then the effect of happening such condition is to annul na daw the obligation as if it had never been constituted at all. So the parties now intend the return of the car. So what are the effects in cases of obligations to do and not to do? So kanina sa example ko, it is a not to do, a prohibition, and you should not go to playmates. I gave you my land on the condition that you would not go to playmates within the year. So here, in some obligations, the court shall determine the retroactive effect of the fulfillment of the resolutory conditions, as in the case where the condition is suspensive. So it is upon the court, or in the exercise of discretion by the court, that even though it may disallow for retroactivity, taken into account circumstances of each case. So yun po. So applicability of 1189. Ano ba yung 1189? Ito yung sinasabi natin kaninang loss, deterioration, and ano ba yung isa? Improvement of the thing. What would be the effect if there would be of the happening of a resolutory condition? Dito have same effects on the creditor as a suspensive condition has. So on the debtor, an obligation arises. So the fulfillment of the resolutory condition converts the creditor into a debtor, and the debtor into a creditor. So yun yung under Article 1189 if the happening of a resolutory condition. So hence, if there would be loss, deterioration, improvement of the thing, and the pending fulfillment of the condition, the parties are entitled to the rights granted under 1188. So yun, kapag fault ni debtor, ano mangyayari kapag may fault si debtor over the loss of the thing under 1188? What would happen? 1188 is retroactivity yun pala, sorry. Article 1191. So under Article 1191, the power to rescind the obligations is implied in reciprocal ones in case one of the obligors should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation with the payment of damages in either case. He may also seek rescission even after he has chosen fulfillment if the latter should become impossible. So the court shall decree the rescission claimed unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired the thing in accordance with Articles 1385 and 1388 and the mortgage law. So here, before we will proceed of a thorough discussion about this article, let's talk about first ano ba yung konsepto ng rescission under this article. So, ano ba yung right to rescind? Ano ba yung power to rescind? So, as a general rule, under this provision, the right to rescind needs judicial approval. So, ibig sabihin nito, dapat the court shall order or the court shall decree for the cancellation or for the to resolve for the cancellation nga ng obligation, 'di ba? So yun po yun it should be as a general rule. However, yun yung ating general needs a judicial approval. However, may mga exceptions Ang mga exceptions naman po natin ay kapag naman may express stipulation na may automatic na cancellation, po pwede yun. Pwedeng wala ng judicial approval. And then, if in cases then that the debtor have voluntarily returned the thing, so hindi na kailangan po ng judicial approval. So, if we have to look further under 1191, ano ba yung kinds of obligations according to the person obliged? Although this article talks about a reciprocal, only applicable to reciprocal na mga obligations. So, may dalawa po tayong types ng obligations according to the person obliged. It's either unilateral o di kaya man ay bilateral. Kapag sinasabi pong unilateral, only one party is obliged to comply with the prestation. So, as an example, I oblige myself to give you my car on October 31. So, yun yung example ng isang unilateral na obligation. So, meron din tayo dito. Kapag bilateral naman, when both parties are mutually bound to each other. So, both parties are debtors and creditors of each other. Kung naalala nyo pa yung ating naging discussions way back under Article 1169, yung konsepto natin ng delay, partly na-touch na natin yung reciprocal obligations. Ano ba yung mga reciprocal obligations? At may dalawa po tayo under bilateral, reciprocal and non-reciprocal. So, let's start with reciprocal obligations. So, here, the obligations arise out of the same causes and are to be fulfilled at the same time. So, arise from same cause and in which each party is a debtor and creditor of each other. Kung hindi man the same time, it could be simultaneous yung compliance such that performance of one is designed to be the equivalent and condition for the performance of the other. So, the general rule is, they are to be performed, simultaneously or at the same time kapag reciprocal obligation, such that each party may treat the fulfillment of what is incumbent upon the other as a suspensive condition to his obligation. So, kung naalala ninyo, yung ating dating example ay para bagang I'll give you my car if you give to me at ang iyong alagang baka, ano. So, hindi po, kung alam sa discussion 1169, hindi tayo magkakaroon ng delay sa reciprocal obligations kapag ang isang party ay hindi po nagfo-fulfill or hindi pa po siya nagpa-perform, diba? So, kahit siya walang period na nakalagay, once one of the parties has complied, it is incumbent upon the other na magko-comply din. So, yun sa atin pong reciprocal na mga obligations. So, here, meron naman po tayong non-reciprocal na obligations kung tatawagin, those which do not impose simultaneous or correlative down na performance on both parties. In other words, the performance of one party hindi daw dependent upon the simultaneous performance of the other. So, let's say, for example, if D borrowed from C 50,000, C, on the other hand, borrowed D's car. So, the performance by D of his obligation, yung 50,000, to C is not conditioned upon the performance of C of his obligation and vice versa. So, parang totally independent yung dalawang ikangang pinasok ng mga obligation. So, non-reciprocal, walang dependency on ang performance by one with the obligation of the other. Although D and C are debtors and creditors of each other, their obligations daw are not reciprocal. Bakit? The obligation of D arises from the contract of loan, utang yun, and then while that C is a contract of comodatum. So, the obligations are not dependent upon each other and are not simultaneous. So, Article 1191 applies only if the reciprocity arises from the same cause and are to be fulfilled at the same time or simultaneously. Kaya po sinasabi ko kanina, under Article 1191, this article is applicable only when it comes to reciprocal obligations. So, consequently, kapag daw ganon, kapag from the moment one of the parties in reciprocal obligations fulfill his obligation, then the other, if the other does not perform his obligation or undertaking, kung na-discuss nga natin sa 1169, and the delay on the the other party will begin. Tama ba? So, the right now of the injured party as being discussed in the provisions, he has a choice. It's either for the fulfillment o di kayaman ay recession. So, ito yung na-discuss na natin din last time. So, ito daw ay alternative. Hindi siya cumulative. Anong ibig sabihin nun? The party, of course, can choose either one lang. So, fulfillment ba ng obligation o di kaya ay recession. Tama ba? Tapos, plus ng damages. So, may karampatang additional na damages na pwede kang mag-demand. Pero daw, if you demand for the performance, you cannot have a cancellation or recession anymore. Tama ba? And if you make a cancellation, then you cannot demand for the fulfillment. However, under nga the provisions, kapag fulfillment would not become possible already, then you may also seek for the cancellation, kung naalala ninyo. So, we have here as an example. In a contract of sale, S bound himself to deliver a car and the necessary document duly signed by him to B on December 1, and B would deliver as well the payment on the same date. Kapag aling si S do not comply with his obligation to deliver the car and the document, of course, B may, in an action for a specific performance, demand for the delivery of the car plus damages. O di kaya man, ay B, may demand from the court the cancellation of the contract with rescission. No. So, here, when a party demands for a rescission in reciprocal obligation, in effect, threats the non-fulfillment by the other party of his obligation as a resolutory condition. What would then be the effect of a rescission? Ano bang magiging effect pag napapa-cancel ang kontrata under 1191? Kasi under ng 1191, take note hindi to, we will be discussing, there's a different cancellation na under our book, under Article 1380 na nag-i-involve siya ng damage at saka injury to the economic interest ng isang tao. Hindi yon. Ang pinag-uusapan natin dito under, ang kino-contemplate ng 1191 ay kapag daw may breach ng contract or breach of faith committed by the person who is supposed to comply with the obligation. So, ano ba yung effect of the rescission? So, there would be mutual restitution, so i-restore, requiring to bring back the parties as far as practicable to their original situation prior to the inception of the contract. So, return to the object of the contract. Yan. It requires mutual restitution to the benefit of each party may have received as a result of the contract. So, it may be carried only through a demand of rescission. And then, yun na nga, for the return or the restoration of what has been tawag nito, restoration dun sa previous nila or prior na situation prior to the contract. And here, the court may grant the guilty party a term for the performance. So, it means to say that the court here is given the discretion or the power to fix for a period instead of canceling the obligation. Kasi usual kapag ang breach naman is light lang or very minimal or immaterial lang, minimal lang or casual lang, then the court will have to fix for the period for the performance of the obligation. Mag-fix siya ng term. However, kapag naman po very substantial nga yung nagiging tawag nito, yung breach ng terms ng kanilang nagiging agreement, then and it has defeated already, yung breach and defeated the object of the parties when it comes to entering the agreement, then the court will order for the cancellation plus the damages, of course. So, but the court as well is not prohibit, the parties here pala is not prohibited pala, obviously, na to enter into agreement if there would be violation, if to have the contract cancelled without the court's intervention. They are not prohibited to resolve their issues. And then we have discussed already with regard to the remedies, which are alternative in reciprocal obligations. So, alternative po siya, hindi po siya cumulative. But in case man na you've chosen fulfillment and it becomes impossible, then po pwede na din ang rescission. And then, limitations on the right to demand for, ano ba yung limitasyon ng right to demand for the cancellation of the agreement as contemplated under Article 1191. So here, what are the limitations and right to demand for rescission? So we have discussed already that judicial approval is necessary in order to rescind a contract, imposing here imposing reciprocal obligation. So under the express term of 1191 nga, paragraph 3, diba? So hindi po pwede na wala pong judicial decree or order para ma-cancel ang contract. So, you have to resort to the court. So, the court, however, has the power to fix na the period instead of canceling the contract, canceling the obligation. Especially nga, as I've mentioned, kapag slight lang or casual, yung lang yung naging breach. And then, yun, fix the period. And the court as well will not actually cancel the contract or the agreement if the object ng obligation ay nasa third person na who have acquired the same in good faith. So, yun po, hindi na po pwede. So, rescission creates the obligation of mutual restitution kasi parang ibabalik natin doon sa prior situation where the parties has not entered into or the obligation has not yet been constituted. Ano yung original positioning nila, no? Ibabalik natin. However, kapag naman there has been a third person who have acquired the property in good faith, then hindi na po pwede na magka-cancel tayo ng agreement. Ano ba yung magiging resort na lang? Di yung injured party may recover for the damages na lang from the person responsible for such transfer. So, here, take note under 1191, the right to rescind belongs only or exclusively only to the injured party. Take note yan. When there is a substantial violation, I've mentioned already, kapag dapat ay substantial, hindi slight lang or casual lang yung breaches para mag-grant po yung cancellation ng agreement. And then, where are we na? Waiver of right. Pwede din i-waive. Pwede din i-waive yung right to rescind. It's either expressly or impliedly. So, as an example, acceptance by the seller of the land sold as a security for the balance of the price ay implied waiver na yon of the right to rescind in case of non-payment of the buyer. So, ang kanya na lang gagawin ay i-recover, i-recover na lang niya yung balance, as against with the land, yung sa balance niya doon sa price. Cancellation of contract without previous judicial decree. So, I have initially discussed this one. Kapag nga naman, ang general rule natin nga ay, general rule natin? The right to rescind needs a judicial decree under paragraph 3 of 1191. However, ay meron po tayong mga exception. Kung meron na pong express stipulation of the automatic nga naman daw na recession, the parties wherein they have entered into agreement that violations of the terms of the contract would cause the cancellation thereof without judicial intervention or permission or termination, or permission from the court or termination. So, here, this stipulation ay ang nature daw niya ay resolutory condition. So, extinguishment, consider this as a stipulation for the extinguishment nga naman ng right. So, here, however, there must be at least a written notice sent to the other party informing him of the recession in cases of extrajudicial recession. So, ito'y outside of courts na cancellation is being opposed or objected to, a determinations of issues by the court is still necessary. So, nagkakaroon man sila ng outside of court cancellation, pero kapag china-challenge or kino-contest yung naging cancellation, then still have to go to court. The necessity of going to court comes into play na naman. Where the contract is still executory. Here, without as an exemption where there is no performance yet by both parties, and then naman daw, one is ready and willing to comply with what is incumbent upon him and the other is not, then the willing party may, by his own declaration, may rescind the contract without previous judicial decree. So, not necessary na that there be a stipulation for providing for automatic recession. So, voluntarily, ibalik mo na lang, yung mga bagay-bagay, So, and then, you have your own declaration of the cancellation kasi this is a reciprocal na obligation. So, here, 1192, before we gonna go with obligations with a period. So, under Article 1192, in case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished and each shall bear his own damages. Ano ba ang ini-express? Ano ba yung kino-contemplate ng tawag nito, ng 1192. Ang sabi ng 1192 kasi daw, what if daw both parties have committed breach of the obligation? So, ang sabi dyan ay, under 1192 nga, the liability of the first infractor or violator must be equitably tempered by the courts. So, it's because the other party is likewise nga naman violating his obligation. So, yun po. If naman it cannot be determined or unknown kung sino yung first infractor who first violated the contract, ang obligations din ng party should be considered as extinguished and each shall bear for his own damages. Yun. So, this means, dalawa ang kino-contemplate ng Article 1192. There, wherein the first infractor is known and the other one is the first infractor cannot be determined. So, if first infractor is determined, then one party violated his obligation, subsequently the other also violated his part of the obligation. So, the liability of the first infractor should be equitably reduced. So, mababawasan dahil nagkakaroon din naman daw ng violation yung the other na party. So, pag hindi naman daw madedetermine, the contract shall be deemed extinguished and each shall bear his own damages. So, it means to say that the contract shall not be enforced. Hindi siya enforced. In effect daw, the court shall not provide remedy to either of the parties who must suffer damages allegedly sustained by them.